Kia ora, everyone. Welcome. We'll get started soon, and we'll wait for people to kind of trickle in, log on to the link, and then we'll go from there. I always find it a little bit bizarre, just kind of sitting here and and not really doing anything while people are slowly coming on. So you can enjoy my ramblings this afternoon while people are jumping onto that link. I've moved to the Manawatu region, and it has been a bit of an adjustment for me, if I can say that much, in terms of weather. You normally living in Auckland, it is unpredictable, but it's not like cold like it is here. So right now we've got a bit of a gloomy day, but the sun's slowly coming out. So hopefully you're getting a little bit of sun wherever you are as well. And yeah, we're really excited to present this webinar. It's been a year since we've done one in New Zealand, which I think is crazy. I really do enjoy doing the webinars here. I'm based out of New Zealand, so it is very close to home for me, and it's always a fantastic opportunity. So I'm really glad that I get to present this one. So we'll get started soon. If anyone's coming on board, don't worry, I'm just telling you all my life history and my stories. And then we'll get things underway. All right, perfect. So I can see that we've got more people popping on, and we'll just give it another minute or so, and then we'll take it away from there. So yeah, like I said, good weather, but it's getting there. So we'll see how it goes. And today is an interesting one because there has been a lot of changes since the last webinar that we did. And it's been an interesting amount of changes in terms of health and safety. We've also seen, timeframes for personal grievances change. So it'll be great to kind of discuss that and get things started. All right, so I think I've given it a bit of time. I can still see people jumping onto the link, but we'll get things underway because we do have a lot to cover. Kia ora, everyone. Good afternoon. Thank you so much for taking the time to join us today for our webinar where we cover all of the employment law updates in New Zealand. Like I said, since last year, about a year ago exactly, we did our webinar on employment law updates in New Zealand. And can I just say, I love doing webinars in all the regions, but there is one thing about doing them for Aotearoa. I love doing webinars for New Zealand. It is my area of expertise. So I'm so excited to be here today. You must be thinking, why is she talking to me? Who is this person? If you've never seen me before. Well, my name is Sanam. I am the Employment Counsel here at Employment Hero. And I have, if I can give you a bit of background about me, well, I love long walks on the beach, sunsets. No, I'm just kidding. We're not here for that kind of conversation. So I am an employment lawyer. I have been working in the employment law space for about 7 years now. And in that time, I have represented both employers and employees across a wide range of issues, as you can imagine, that come up in the employment law space and across different industries. And as well as doing a 2.5-year stint focusing on advising the hospitality sector, so advising employers during that time. So you can imagine at the height of COVID, what that would have been like with the wage subsidies and the uncertainty. So I'm glad that we're kind of out of it now, but it was definitely an interesting time, I'm sure, for a lot of businesses out there as well trying to navigate. Now we'll do a little bit of housekeeping. I just wanted to say that this is being recorded, so please don't worry about frantically writing anything down. We have made this a Q&A webinar, so that means that you get the opportunity to ask me questions. I promise I will try to get through as many as I can in this webinar, but if anything happens where we don't get to all of them, then I will endeavour to send you through some information after the webinar, and that will be sent out along with the slides and the recording. So you're all sorted, don't worry. And we'll have polls throughout the webinar as well. I'd love for you to participate. It's a way for me to also understand kind of the landscape and what's happening in New Zealand across all of these businesses, and we love that information. So absolutely feel free to participate in that. And like I said, it will be recorded, so don't you worry. Now, a disclaimer, this is provided to you in good faith. So please make sure that you, take this kind of in terms of it being just information. And if you're dealing with anything in particular, so let's say you're dealing with an employment relationship issue or any problems around that, then please go out and seek legal advice. There is nothing better than getting specific tailored advice to your circumstance. So absolutely tap into that. Now, like I said, we will have our Q&A portion as well, and that is going to be where you can ask me questions. So use the bottom of your Zoom screens, the boxes down there, and you can start firing them away as we're talking about each topic. In terms of today's agenda, like I said, a year has passed. It's been a long time. So we will cover 2023 changes all the way up to what's happening this year or what's already come and what we're looking forward to, or maybe not, and what lies ahead in the future in terms of the coalition government's kind of proposals and what they've hinted at or indicated, that they're going to be starting to look at. So from there, we'll cover all of that and then get into the Q&A portion at the end. So definitely stick around for that. So we'll kick things off by talking about the first change, which is actually something that came up last year in June. It's the changes to health and safety. Now, on the 12th of June last year, this actually came up where we saw a change to the health and safety at work legislation. Essentially, what's changed is to do with representatives and committees. So you may be wondering, Sanam, what is a health and safety representative, especially for people that don't deal much with health and safety in the workplace? Generally, a representative is a worker that's been elected to represent the other employees in the workplace on health and safety matters. So it's basically giving a voice to these employees so that they are able to voice their opinions and go through the representative without worrying about any kind of pushback or anything like that. So that was the whole point of having a representative. Now, what's actually changed is that the law previously said that if you were a PCBU, which is a person conducting a business or undertaking, so generally, let's say it's an employer, if an employer was approached to have a representative or a committee, and they were asked, hey, can we form a committee? Can we get a representative elected? Then the PCBU could actually decline. So the employer could say no if they met, two criteria. So one is that they had less than 20 employees or workers at the time. And then the other one was that they weren't in this high risk sector or industry. But that has now changed. So the whole point of changing the legislation to allow for everyone across the board to access representatives and to have committees is to make sure that everyone gets access. So the main prerogative of the law change is that it increases the ability for employees to have access to somebody that can kind of represent them in these health and safety issues, and they are able to voice their opinions. So let's talk about the exact changes that have come up. So I've listed the three main changes there on the slide. You'll see that the first one is that if a worker approaches and says, hey, look, we want a health and safety representative, and we really would like somebody to come on board and for that to happen, then that's where the employer would need to consider this and have a look at electing somebody as a rep. You may be wondering, because the first question I thought of was, okay, how long do I actually have to kick this off and to actually do this? Well, you have about 2 months from the date of the request. So from the date of the request, you need to have that 2-month time frame to initiate an election process. So get things underway. It's always better in employment law to act on things quicker rather than later because things can snowball. So keep in mind you have a 2-month time frame, but it's always a much better situation to kind of get things moving and get the ball rolling. The next change is that if you have a health and safety representative, or 5 or more workers that are saying, hey, look, we want a committee, then the PCBU or the employer would really need to consider that. So you will need to have a look at putting in a committee as soon as practicable is what the legislation says. So just keep that in mind. Like I said, better to get things moving a lot quicker than leaving it for later. So just always be mindful of that. And the last thing which has changed, which kind of ties into what I was talking about a bit earlier, which is the fact that a high risk sector or industry, that doesn't matter anymore. Everyone has access to this. Everyone has access to be able to initiate elections and to ask for a committee. So those are the key changes. Now, what I would like to say to you is that you need to be mindful of the fact that the Act does not make it mandatory for businesses to have representatives or committees. So just keep that in mind. It's not saying that now the law has changed. What are you doing? You haven't put this in place. absolutely not like that at all. The Act actually just allows for a pathway for employees to ask for a representative or to ask for that committee. So you'll only be required to initiate an election for representatives or establish a committee if there has been kind of a request from an employee. So you're not being thrown into the deep end and being told you have to do this now. So don't worry if you haven't done it yet, because it's not required unless you've received that request. So we'll move on to the next change that's happened, actually quite close together. You may have heard about this. It was a lot of building up to this, and then all of a sudden it kind of just got passed, and then we saw things coming through, and I do believe there has been a little bit of chatter since then, but maybe not a revisit. So this is a good time to just double check and make sure that you've got everything down. It's to do with the time frame for raising a personal grievance when it comes to sexual harassment. Before, we used to see that the time frame was 90 days, just like it is for other areas of raising a personal grievance, but that has now changed. So as of the 13th of June last year, that has changed. It is now 12 months. So I believe that this is to do with, it is a severe case when you're dealing with these kinds of issues in the workplace and these allegations. So it does require, in terms of the employee, kind of navigating their mental health and things like that. So that's why it was a pathway to allow for more time for these employees. Now, in terms of what you need to do as an employer, check your agreements. I would highly, highly recommend that you check your agreements, make sure that you've included this into the agreement. You will probably notice if you are somebody that has been reviewing the agreements for your company, or you've been issuing them out, when you go all the way towards the bottom, usually the bottom part of the agreement will have something in there around the simplified way to resolve an employment relationship problem. So there will be something in there that will say maybe, the employee is able to raise a personal grievance within 90 days for X, Y, and Z. That needs to be slightly changed to account for sexual harassment being within a 12-month time frame. The reason why it needs to be changed is, one, because the legislation has been passed, but two, it is also an act of good faith, right? You've got to be clear in your communication. You can't mislead the employee, or you shouldn't be doing anything to hinder communication, and that's why this is definitely a requirement. So in terms of your old agreements, let's say you've got existing agreements in the workplace with your employees, that doesn't necessarily have to be updated. I always suggest to update your agreements if you are just generally changing a few clauses here and there. Let's say your rest and meal break clause wasn't up to date. It should be up to date because it's been a while, but if it wasn't, that's okay, no judgment here. If your contracts are not up to date, then you can use this in one swift kind of a variation, or one swift new time to update the contracts. So just keep that in mind. But definitely you need to make sure that this is implemented in any templates that you have for future employees. So just update those. It goes out to all of the employees that you have, and it should just be nestled very neatly into the employment agreement, and it just requires an extra sentence about the time frame. So keep that in mind. Definitely change the templates that you have. Speaking of kind of changes last year, the next two are probably the biggest changes that we saw, and the reason being is because, as many of you know, the government has changed. We had the coalition government come in, and they put forward a 100-day plan, and as part of that 100-day plan, there were a couple of changes that they made. The first one was scrapping fair pay agreements. If you're an employer or you're in this space, then you 100% know that fair pay agreements was the topic of the last couple of years. And last year, we saw that the fair pay agreements have officially been scrapped. So as of the 20th of December last year, fair pay agreements completely repealed. So I don't want to hammer into this too much, but if you turn your mind to fair pay agreements, essentially it was just to bring together employees, unions, organizations to agree and bargain on key terms in employment, or the minimum terms that they would like across the sectors or the industries in terms of employment. But like I said, that has been done. We are now repealed when it comes to that. So another change that has come up with the new coalition government, and we saw, a bit of a shift, but it's nothing new to us. Keep that in mind. Is the 90-day trial periods. Now they're available for everyone. So if you have a 90-day trial period clause in your agreement, then that is great. You've done the part. But if you don't yet, then it's something for you to consider. So if you have used trial periods before, then you'll know kind of what they're all about. But if you haven't, then trial periods usually are set for 90 days. You can have them less, but 90 days maximum. Keep in mind, 90 days does not mean 3 months. 90 days means 90 days. So a lot of times people will think that, 3 months will equate to that, but sometimes it goes over. So just be mindful of that. Usually what that trial period is used for is to assess the employee's suitability in a particular role. So you're trying to figure out if they kind of work for the role, if they're a good fit. And generally, if everything is done right, all the boxes are ticked and you've done everything perfectly, then you are able to terminate the employee and you don't have to worry about an unjustified dismissal claim there. Remember, the employee can always raise a claim for other areas like discrimination or any other human rights issues or anything like that. So just keep that in mind. Now, I say that this is a bit of a change, and I know that I mentioned that before. The reason why I said that was because this is not new to us. We have actually seen trial periods come in, come out, and it's usually where the government kind of changes. And what we've seen is in 2019, if you remember, and if you still got your trial period clauses in your contracts from then it was only acceptable for employers that had fewer than 20 employees to have the trial period clause in them. So that came in May 2019. But like I said, on the 22nd of December, that has been changed now. So the bill was passed. Trial periods are now fully in effect for all businesses, but keep in mind, having the trial period clause doesn't just make the trial period valid. There are certain requirements that need to be met. For example, not having a probation period and a trial period running concurrently in your agreements. I know personally that this happens a lot. I think when I first got into advice, we were doing the same thing. So I have learned from that now. I promise I'm getting better. But it's really important not to have both clauses in the contract at the same time. Other than that, a trial period clause is something where it needs to meet certain criteria. So under the Employment Relations Act, it does set out exactly what's required, and it does detail exactly what's needed to meet the criteria of the clause. But if you remove the clause and just look at the other things that are needed, you might be wondering, okay, Sanam, what else? Well, I've included a fact sheet in there in the slides, which will be provided to you. So keep that in mind. We'll also send out the fact sheet as well separately after the webinar. So just keep an eye out for that. But essentially, it goes through the requirements of a trial period, like having a written agreement is really important. Yes, funnily enough, you might be looking at me going, okay, Sanam, everybody knows that. But there are a lot of businesses that don't have one in place. So it's really important to detail the clause, like I said, and meet the legislative requirement. Also really important to notify the employee of the trial period inclusion in the contract, in the employment agreement. So you can't just have we know from cases that you can't just have the trial period clause in the contract. It needs to be mentioned in an offer letter, and the employee needs to be well aware that it's included in there. The next thing as well is that the contract needs to be signed. The employment agreement needs to be signed well and truly before the employee commences. Even if it's a day before, still really critical, still really important to make sure that you have met, the criteria and the requirements. So those are just some of the things that are required. There is a whole raft of them. There is a whole list of them. And that's why I say a trial period termination. Don't be fooled, my friends. It can get very tricky. It can get very complicated. So it's really important that if you're trying to do one and this doesn't seem right, or maybe it's your first one, go out and seek some legal advice. There's no harm in doing that for the first one and then feeling a lot more comfortable if you ever have to do them again. So definitely keep that in mind. And like I said, we'll provide you with the fact sheet. So hopefully that will give you a little bit of information around what to look out for and how to navigate. Now, speaking of trial periods, I'm going to take you a little bit further back to last year. I know it feels like we're bouncing around a little bit, but this nestled in very, very well with this topic. On the 29th of October, there was actually a change last year to the accredited employer work visa. So if you hire migrant workers and if you're an accredited employer, then you would 100% know about how this, accreditation process works and everything like that. If you don't know, then that's fine. We'll just sit down and talk about this, and then it might be something new that we're learning. But generally, with an accredited employer work visa, you would do a job check application, and it's a way for employers to, under that particular visa, get migrant workers to come to New Zealand. Now, what has happened here is that the 90-day trial period has actually been removed from employment agreements. So you can no longer use a 90-day trial period. You may be thinking, okay, that's great. Why are we talking about this? Why does this matter so much? It matters because I want to watch out for your backs because of the fact that when you have a 90-day trial in these agreements, now that there has been this change, what can actually happen is that when you're doing your job check application, so when you're processing and putting the application through, the Immigration New Zealand can turn around and say, look, you haven't actually followed what we've asked you to do. Your application is either declined. That's, a bad situation, that's for sure, and you'd have to reapply, which delays the process. But even worse is you can have your accreditation revoked. Yes, that is right. You can have it absolutely revoked, which I think is crazy. But that's why I said this is one that I really wanted to focus on for anybody that is using the accredited employer work visa or going down that route. Then just keep that in mind. They can do the accreditation being revoked at either the job check process, they can do it at the post-decision process, and even at the re-accreditation process. So many avenues for them to say no. So just keep that in mind, and it's better to be on the safer side. Now, I promised you polls, and I am going to give you one now. The poll that I'm going to bring up is to do with you preparing your employment agreements with the 90-day trial. So with the changes that have come up, I wanted to know, have you updated your employment agreements? It's always good for us to get an understanding of what everyone is going through out there. So please let me know, participate in this. We're going to be sending out the answers after the webinar has kind of finished. So, so just keep that in mind. So you won't see the answers pop up now, but we will definitely be sending it through to you. Hopefully people have updated their employment agreements. I know people are a little bit conflicted about using the trial period, but I do find it a lot easier than using the probation period. So have a look into both and see what works mostly for your business. Now, the next thing that has changed, and now we're into 2024, so yay! Now we're kickstarting the year and keeping on the migrant worker topic. It is worker protection changes that we are looking at. So there have been some significant changes in this space, and actually, funnily enough, you may be thinking worker protection, migrant worker exploitation. How does this impact me if I don't really hire any migrant workers, or if I don't do that well? Let me tell you, there are a lot of interesting changes that have happened, because this piece of legislation that came in on the 6th of January, it changed things. It shook things up in terms of what requirements are there across several pieces of legislation. So we're talking about changes to the Companies Act, changes to the Employment Relations Act, and changes to the Immigration Act. So you can see from this that it's not just specific to migrant workers. We're talking about worker protection and exploitation in general as well. Now, usually when I say migrant worker exploitation, or we say, worker protections, the first thing that you say or you think is modern slavery. Now, it doesn't only mean modern slavery when we're looking at worker exploitation. You're looking at things like maybe excessive or unlawful deductions, even all the way to excessive work hours, working conditions that have been exploitative, and then not even something like, I say as simple because sometimes it's easy to get this wrong, just because, the employer and employee may be disagreeing on something, but non-payment of wages or failing to meet the legal minimum entitlement. Sometimes your payroll systems have not done things correctly. So it's really important to stay on top of this and be quite compliant when it comes to these things. And the reason being is because there have been new offences and infringements for certain areas. So the first one is the Companies Act. Now, this is a major change, I would say, just because time and time again, you will see businesses that will come out in the media about the fact that they've been pulled up on worker exploitation. And if there has been any person convicted of migrant exploitation or people trafficking, then under the Companies Act now, they can be disqualified from managing or directing a company. That is quite serious. The purpose of the legislation was to stop people from bouncing around and to stop employers or directors of a company to just jump ship and go to another one after they've engaged in this conduct. But that means that you can be disqualified and you won't be able to be in that position. So just keep that in mind. I think the biggest changes, though, which I really wanted to focus on here, was to do with the Employment Relations Act and the Immigration Act. Now, the reason why I say this is big is because before a labor inspectorate may come in, immigration officer may come in, they request documents. I've been involved in many of these processes myself. And you endeavor to try to get to all of their questions and provide them the documents. They might come into the business, you're going through your filings and doing all of that kind of stuff and trying to give this to them. But you would have some time under your belt, effectively. You would have some time to get your things in order. You could keep them in the loop. And generally, for the most part, they are quite constructive and they do work with you to try to, help you and give you the time that you need to get that information. Things have changed. So I'll focus on the Employment Relations Act first, because the Immigration Act is a little bit longer in terms of the changes. So the Employment Relations Act, there are new infringement notices and penalties that the Labor Inspectorate can seek at the Employment Relations Authority level. So those are the new things that have come up there. I've listed them on the screen, so just feel free to have a look at that in your own time. Like I said, we'll provide you with the slides, but that's just generally the guidelines in terms of the infringement. What is significant, though, and I really want everyone that's on here to really get this one, is that if you have a labor inspectorate coming in, and it's not because necessarily you've gotten a complaint, sometimes it's just a labor inspectorate doing a random audit. If they've come in and they've asked you for employment documents or employment-related documents, you now have 10 working days, within 10 working days, to supply this to them. That means it is extremely critical for all of your documents to be in order and to be up to date, and for you to make sure that you have ticked every single one of those boxes in terms of compliance for your documents. So it's no easy kind of feat. It's definitely a difficult thing to do, but we'll talk a little bit about how we can make life a little bit easier. But just keep that in mind in terms of what's required. Now, the Immigration Act, similar changes we've seen here too. And when I say similar, I mean the 10 working days to provide the documents to an immigration officer. So sometimes you might have an immigration officer coming in. The immigration officer might say, hey, look, we want to have a look at this piece of information. We want to see, what's going on with this particular employee. Maybe they're also doing an audit. Then you need to provide the information to them within 10 working days. So you can see, again, very critical. You have a time frame now. The infringements and the penalties relate to the fact that you're not supplying the documents in time. So don't get caught up with that. Definitely have all your ducks in a row, especially when you're dealing with, inspectorates coming in, officers coming in. Now, there's 3 new infringement offenses under the Immigration Act. One is that the employee, if they're not supposed to be working, then they shouldn't be working. And if they get caught out, then that's an offense. If they breach their visa conditions by, let's say, working for you, sometimes the visa conditions are tied to a workplace, sometimes they're tied to a particular salary amount or a wage amount, and we'll talk about that change as well. All of those things can lead to an offense, and then also failing to supply those documents. So keep that in mind. It's really important and really critical for you to make sure that you've got all your ducks in a row when it comes to that. I know I'm hammering on to this point, but I'm an employment lawyer. Compliance is my passion, I guess. So the last change for the Immigration Act is to do with the fact that you can be named and shamed. So we've seen this time and time again. I know that Burger King has been notorious for having their name out there. I remember when I first got into employment law years ago, I saw Burger King come out and I thought, oh, like people put their names out there, like, Immigration New Zealand really does this. But now the chief executive of the Ministry of Business, Employment, Innovation, they can turn around and basically say, look, these are the particular employers that have offended under or against the Immigration Act, and we are basically naming and shaming. So please don't be on that list. I would never want to see any of you on that list. So just keep that in mind. These are the changes that have come up. I know it's quite a lot of information, but we will be providing the slides to you, so no worries there. Now, minimum wage, we're 3 days in. Minimum wage has increased officially as of the 1st of April, and we have seen a refreshing change, I would say. For some people, I know that they might not be agreeing with me, but I do think that it's been quite refreshing in the sense that we've seen the minimum wage only go up 2%. So it is now $23.15 for adult minimum wage, and then $18.52 for the starting out training wage. Now that is still 80% of the adult minimum wage. I don't think there was too much they could do there, but keep in mind that this is definitely a better change than what we've seen in the past, which has just been going up and up. If employees are under 16, I'd just like to point out, because I do get this question often, if they are under 16, there is no minimum wage. That's right. I always joke around and say you could technically hire a 5-year-old, and the minimum wage would be whatever you want to set their minimum wage at. So you could absolutely have people in the workplace that are under 16. They have parameters around how they need to be working and the times that they need to be working, but no minimum wage there. So I just wanted to cover a couple of things on the minimum wage, because I do think that there's this, I'm going to say, misconception, and I know that it sounds a little bit bizarre for me to say that, but when it comes to the minimum wage, I do think that there's this misconception that everyone needs to be just given the increase, and then that's it when they're sitting on that minimum wage mark. But that's not necessarily true. It's not about just focusing on the wage. Yes, if they're on the minimum wage, then you absolutely need to make the change. But it's also a great time to check my starting out employees. How long have they been here? If they've been here for enough time, have they ticked over to the adult minimum wage? Have I actually put this in writing to my employees? Have I told them that, hey, look, your contract is varying because the minimum wage has changed? There is no harm in documenting a positive change, because it is an essential term in their employment agreement at the end of the day. I know there's a lot of people out there that might be rolling their eyes at me, but I promise you it does make a huge difference. I have seen some employees fight back around the minimum wage. So just make sure that it's well documented, you've got everything covered, and you put it in writing effectively. So just keep that in mind. That's something that I've found really helps in everyday practice, but completely up to you. So we'll go on to another change in wage, and that's actually been quite recent. Well, I say recent, we're in April now, aren't we? The 28th of February brought about a very interesting change to the median wage. We have seen the median wage go up and increase quite regularly on a yearly basis, and this year was no different. We saw that the minimum wage, or the median wage, increased to $31.61. So previously it was $29.66. Then it increased. What I can say here, though, is that this only applies for certain categories of visas. So I've got the visas listed there. We've got skilled migrant, we've got green list categories, so we're talking straight to residence, we're talking work to residence visas, and then you also have the parent residency class. So we've got different visas here that qualify for that $31.61 per hour, but for accredited employer work visas. Interesting announcement and interesting change was that the visa does not change for this particular for this particular class. So for $29.66 per hour, it's still set at that for the accredited employer work visa. So that is not going to change from what we can see. It's also the same for anyone that taps into the accreditation visas that may be linked to that visa. So sometimes it's a partner of a worker work visa or something like that. So just keep that in mind, that doesn't shift and that doesn't change. Again, if you're dealing with anything specific, immigration is one confusing place. Migrant workers can get into a very difficult topic there when you're dealing with kind of all of the things around eligibility. So definitely speak to an immigration advisor or even an immigration lawyer in your area if you're dealing with anything. So just keep that in mind. Now, one of the final changes that we're going to talk about is to do with hurt and humiliation. So you may be saying, okay, what is hurt and humiliation? Why is it also in quotation marks? And it's because one of the key remedies that we see at the employment courts, at the Employment Relations Authority, is the ability for an employee to seek compensation for a successful personal grievance claim. So it's a remedy for damages that this employee may have gone through. And generally, the way that it's classified under the Employment Relations Act is that it's compensation for humiliation, loss of dignity, and injury to feelings. Somewhat long-winded, so that's why we shorten it, and sometimes we say hurt and humiliation, or we say injury to feelings. Now, you may be wondering, why do I need to know? What's the situation here? Look, it's more of a, and I want no one ever to go through a personal grievance, but it's more for somebody that has either dealt with one, or maybe you are going through it, or maybe you just need to know just in case. This is more for somebody that needs to kind of understand the landscape in terms of what needs to be paid and compensation. So compensation is something that we also may look at outside of the courts and outside of the Employment Relations Authority. You may be, it may come up because you're trying to settle a personal grievance kind of off the record and outside of any formal process. If that is the case, then you want to be well prepared and know where you fit in with the criteria and the bans. So when I say bans, in 2017, there was a case that came out. There was a case called Archibald. There was also a case against a very reputable honey manufacturer and Rotorua, I believe it is. And those two cases, they kind of set the scene because what they did was they took a banded approach to hurt and humiliation. They basically, the court sat there and said, look, we need to have a look at set criteria, because for so long, all we do is look at a previous case and kind of compare and see if anything falls in the similar bracket. But what we need is clear guidelines on what you need to meet in order to meet each band. So the first band that has now changed, and I've put this on the slide as well, is the first band is up to $12,000 for low-level damage. When we say low-level damage, we're talking about maybe a process wasn't done, maybe there's a procedural defect, but that hasn't caused a lot of harm and injury to the employee. It's more so maybe to do with a misstep in a process. Band 2, we're looking at now issues where the employee has suffered a middle range of harm and humiliation or loss of dignity. So maybe they have suffered anxiety from this. Maybe they have been, finding it quite hard to adjust to a new workplace because of PTSD. It can range and it can vary, and you can see the bracket from 12,000 to 50,000 is quite a big bracket. So generally what we see is things that go to the authority. They could fall smack dab in the middle of that band 2, but you can never really tell unless you have the full facts of the case and you're kind of looking at each aspect of the case. But generally that's the pattern we've seen. Now with band 3. Band 3 is an interesting one because we had a certain case that came out I think it was this year, I believe it was Parker and Magnum Hire. And that case was very, very interesting in setting the scene. So this GF and Customs case, this is the one that reset the scene for the bans. Basically, the chief judge in that case turned around and said, look, the bans used to be up to 40K. We need a bit of a refresh. We need to consider inflation. And because of that, we're upping up the bands. So these are the bands that you see on the screen that have been upped. But what we need to always have a look at is, okay, even though this has been set in cases, what's been the discussion around it? What's actually going on? Have the courts adopted it? Has the authority adopted it? And that's when in Parker and Magnum Hire, we saw fully that the courts had adopted this. And the reason why they adopted it is because the employee was given a whopping $105,000 in compensation. So we haven't seen many cases like that go ahead. And I wanted to talk about it a little because band 3 is something that is a bit rare, but we are seeing more and more cases coming up solely because of the reason and the space that we're in. So when you're looking at these employees that are reaching the higher end of their compensation, it's usually because they've had severe PTSD, they've had severe anxiety, depression, they're finding it difficult to navigate into the workplace, and this isn't something all the bands. This isn't something where the employee can just turn around and go, this is how I'm feeling, this is what's going on. It needs to be backed by evidence. So they do need to provide and bring something to the table in terms of doctors' opinions and psychologist reports, or even witness accounts, eyewitness accounts, or anything like that. So just keep that in mind. And again, the reason why I wanted to bring this to you was because I wanted you to understand that these are the particular areas that have changed, and also that at the end of the day, if you are dealing with the personal grievance, then you kind of have a rough idea of where things sit in terms of what the employee should be asking for, and when you're negotiating what you should be counter offering or maybe offering, depending on which side you're on. So just keep that in mind. And I do believe that this is well and truly adopted now. So we'll tie everything off by looking at what kind of is coming up in the future. So if you know, our minister, when it comes to kind of safety and employment relations, Brooke Van Velden, she came up with a speech that she provided to the Business Chamber, and that speech detailed a bunch of changes that the coalition government is putting forward. Now, before we get into it, I just want to say this is not set in stone. This is just what the coalition government has put out as kind of an introduction into what they're going to be looking at. We don't know what the dates are for this. We don't know when this is going to be implemented, but just keep that in mind. So the changes are, and if I could just simplify it into one sentence, it is to make everything simpler. That is their prerogative. They want to make things simple. They want to simplify the whole process. And first, cab off the rank, first on their list is the Holidays Act. If you have been around for a while, then you know that the Holidays Act has been getting a refresh since 2018. We saw the Holidays Act task force being put together. They were saying that that's going to have a refresh. Then we saw, a lot of back and forth and proposals put forward. But what the minister has said is that, look, this is overcomplicated. The whole suggestions around how to change the act and the Holidays Act is complicated. Let's pull this back. So what the minister has said is that the last government's proposal was too complex to fix the problems. We need simple fixes that employers understand. And so they are definitely working on doing that, and they will be getting people to weigh in as well. So just keep that in mind, that there is opportunity for the public to weigh in. I definitely know people that we partner with at Employment Hero, like NZPPA. They are all, weighing in on this topic, especially being in that particular space when it comes to payroll. So it's time to have your say if you do want to do that. And another change that's coming up is to do with, and this is what, like I said, has been proposed, nothing set in stone, is health and safety. If I could sum it up in one way, like I did before, it's to make things a lot simpler, because the coalition government is saying that our legislation at the moment and the kind of the clauses that we have in there are quite purposeless. So our act doesn't actually address the cause behind worker harm, and it moves, and we want to move away from this, legislation that doesn't really have a place in terms of actively trying to fix these things in the industry. So keep that in mind, that's another shift. Whether you're an employee or an organization, if you are impacted by health and safety, then they definitely want to hear you, and you should have your say. So just keep an eye out for that as well. Now, this one is a bit of an interesting one. I thought it was quite interesting to call out the Employment Relations Authority, the Labour Inspectorates, and WorkSafe, also Labour Inspectorates calling out MBIE. Basically, what the minister has said is that things are getting delayed, things are slow. We want to ramp it up, and the only way we can do that is these frontline services. They need to be set with performance targets. So it's all about reducing, high compliance costs and making sure that that these frontline services are actually moving things ahead, and they are making things happen as quickly as they can. So just keep an eye out for that as well. It seems like the processes will be getting faster. I know that when we're dealing with the authority matter, that could take months to a year, and everybody always seems very shocked, but unfortunately that's the way that the system works. Now, the thing that will get the biggest shakeup from what's been proposed is that there needs to be a better balance between employee protection and regulatory flexibility, and also the certainty of obligations and outcomes. This will all come up in the Employment Relations Act. Now, there's a few sections or few parts of the Employment Relations Act that may be changing. The first one is to do with contractors. We all know that like contractors and having contractors can be tricky. The line between them becoming an employee and being a contractor is very fine, and sometimes it can be blurred. What the minister is proposing here is that individuals that agree to a contracting arrangement, and they're fully aware and they've agreed to the terms and the agreement and the contract, they are not able to argue that point, because it should allow for businesses to have a lot more certainty. And it should allow contractors to know that their relationship or contracting relationship shouldn't be hindered by, here's an employment agreement, because this is getting to a stage where you're more like an employee. So that's the first area. The next one is when it comes to personal grievances. This is a bit of a different change and suggestion. And I know that a lot of people will have opinions around this. So it'll be kind of interesting to hear what you have to say in the poll. But the government has suggested the implementation of a threshold or a salary cap for raising personal grievances. We have something similar in Australia. If you ever have seen that, the salary cap, I think, is 167,500 for the employee to be able to raise a personal grievance claim. Anything above, at that or above that, the employee doesn't have any rights there. Now, introducing this, like I said, it's a bit of a contentious one. I know that there's going to be differing opinions on that, but please don't shoot the messenger. This is just what the proposal has been. Also, coming under personal grievances is removing the remedies for a personal grievance if the employee has contributed towards the personal grievance, to their own personal grievance. This one's interesting too, because what we have seen in certain cases is that if the employee goes ahead and they end up saying, hey, look, I'm raising a personal grievance, and during the process, when it goes to the Employment Relations Authority, it comes out that the employee actually contributed towards it, there is usually a reduction to their compensation there. So I've seen cases where it's gone from 20,000 to 8,000 and situations like that. So this suggestion by the government is to completely eradicate that and not even allow a path for the employee to go down, but just watch the space in terms of the changes. Now, another thing as well is to remove or simplify the personal grievance process. So not to remove, sorry, to simplify the personal grievance process. So it does seem like the personal grievance process can be quite lengthy, and I wonder if this ties in with the performance goals for the other departments or the other areas of those frontline services. So these are kind of the changes in terms of what lies ahead. Like I said, we don't really know 100% what's going to come up, but this is just what the minister has proposed. So definitely watch the space, keep an eye out, subscribe to all of the parliamentary, information that comes out if you want to be involved and to have your say. I definitely see a lot of organizations out there doing it, so there's no harm in having your say. All right, so we'll go on to the next poll. And this is just about, like I said, I want to know about what you guys are feeling. How do you feel about this whole new change that's being proposed? Do you feel optimistic? Not so much? Or do you need more information? Because I know that a lot of that stuff is quite vague. So there hasn't been too much detail around it. Now, what I'll do is I will kick off into the Q&A side of things. But before we get into that, what I will do is just cover off, like I said, there are a lot of issues when it comes to staying compliant and making sure that things are all done correctly. I think the biggest thing and the biggest message I can drive today is that one of the issues that I always see is documentation. The fact that documents are not nestled in one neat place. It's very hard to stay on top of your employees. And I believe that that's where, you know, our wonderful product can come in terms of providing you with policies all the way through to giving you the ability to have digital contracts, just so you're not scrambling. Like I said, if a labor inspectorate came in, you'd be scrambling for documents. A lot of times they're sitting on some weird drive or they're in your inbox and in your email. So this is a good way to help with compliance and making sure that you've got all your ducks in a row and everything in one place. Even something as simple as recording your catch-ups with an employee, just to be able to do that and not have to worry about frantically writing everything down on a piece of paper and keeping that somewhere. So long gone are the days of the filing cabinet. Now everything is all digital. So definitely keep this in mind because it can be a great asset to have in your workplace. So now the Q&A side of things, I definitely can see the questions pouring in. So I will kick things off and we will go ahead and start off with the first one. Sorry, it may be a little bit spaced out, but I promise that I will, I'm just trying to read and do this at the same time. So in terms of updating existing agreements, I got a question around what is the best way to update existing agreements and to make sure that all the employees are covered. With existing agreements, if you really wanted to do it, then you could just send out a variation to the employment agreement to just say that this particular area has changed. But it's completely up to you. Like I said, with already implemented agreements, it is a nice to have more so than a legal requirement, but it is definitely essential if you have provided a new agreement to an employee and you haven't included it in there since that June date. So always a better situation to just update the agreements as they go. A variation is great, but the problem with this is that you don't want to keep doing variation upon variation upon variation. Otherwise, that already 20-page document is going to get longer. So pick and choose. And if you are doing a full suite of changes, you might as well just do it in one swift blow and just issue out a new contract if you're changing non-essential terms. So don't just shove a restraint of trade or something in there and offer this to the employee. That's not the ideal situation. So I'll just have a look at the next one. Okay, so somebody's asked about the sexual harassment clause that they have in their employment policies, whether that's enough or it needs to be in the employment agreement. It 100% needs to be in the employment agreement. It is essential. It is essential for the employee to have that in their agreement. Sorry about the noise, everyone. It is essential for them to have that in the employment agreement. And it is really important to move, to have this for employees moving forward. So just keep that in mind. And a policy, great to have it in there, but agreement is always important as well. So another one is around the 90-day trial periods. So 90 days, whether it's a work day or a 90-day calendar day, look, it is a really interesting one. A lot of people say, is it business days? Is it calendar days? It's 90 calendar days. So from the date of commencement, that's the day it starts. And please make sure that it is very clear. The amount of contracts or employment agreements that I have seen where that 90-day is not clear in terms of when the employee commences work, you just really need to make sure that that's stood out and that's very important for the employee to understand. Now, is there a time frame for past hires? Whoever asked this question, it would be great to understand. I'm guessing that this might have to do with the sexual harassment side of things and raising that personal grievance. In terms of the time frame, there isn't. If this has to do with the 90-day trial period, then please make sure that you are not including a 90-day trial period in a contract or an employment agreement for an employee that has already worked for you. If they've worked for you in any capacity, even as a casual independent contractor, I know it's meant to be a contractor relationship, but if it's starting to blend into employment, better to be safe than sorry if you are offering them, permanent employment or anything along those lines. So just keep that in mind as well. And in terms of, I'll just have a look. So somebody's asked, I love this question, how does a probation period and a 90-day trial period differ? The first difference is that you cannot have a situation where if you've done everything correctly, let's say perfect world, done everything correctly, all boxes are ticked, everything's great. you can't have a situation in a 90-day trial period where in a probationary period where the employee can be barred from raising a claim against unjustified dismissal, whereas in a 90-day trial period, that is the case. The other differences, which a lot of people talk about, but it's usually quite hidden or it's, somewhere else, a lot of the issues that can come up is around how the process works. So under a 90-day trial period, effectively, if you've done everything right, the termination is quite swift. And like I said, if you're dealing with it, definitely go out and get advice, but the termination is quite swift compared to a probation where you're still required as an employer to do all of the processes and to meet all of the requirements. So if you're doing a performance process, you still need to hit all of the performance process requirements, doing the PIPs, doing the warnings, and then finally looking at terminating. So it's just taking processes and shortening them slightly to fit into that time frame. So I would always suggest, if you have access to a 90-day trial period, and as long as you've gotten it right, it's a lot better because it's a less arduous and long process. And if somebody's asked if you've already have a probation period in the contract, do you also need to put in a 90-day trial period? You pick one or the other. So I would say look into it, find out what works best for you. But it's always good to have one or the other, not to have both running concurrently. So somebody's asked if we have learning tools for leaders in relation to 90-day trials. We will be sending out a fact sheet, so keep an eye out for that. That has all of the details in there, and also it will have information about kind of how to navigate it as well. If you use our platform, we also have, I have designed these. We have templates on there for how to do the 90-day trial terminations and how to go through that process. So another one is, so the adult minimum wage is for anybody that is, depending on the circumstance, they could be above the age of, so 16 and above. Usually that particular employee, that 16 or 17, can be on the starting out wage, but the problem there is that they can only be on that for a set amount of time. So I got a question around how old is the adult minimum wage, and with the adult minimum wage, like I said, the person can tick over. So just keep in mind that you're looking at the parameters and the time frame. I believe it's 6 months employment if they're 16 or 17 and starting out with the employer for the first time. But we will definitely send out information along with the slides around that as well. So there isn't, you'll be surprised. You can be quite young in terms of being on that adult minimum wage, and that can cause issues for the workplace. I'll just have, so somebody asked around accredited employers and just clarifying if they're okay to keep 90-day trials for employees that are not visa dependent. Yes, absolutely. You can absolutely do that. It is not a requirement to have the visa process kind of done or anything like that, other than making sure that the 90-day trial period is not included in those ones. So you can absolutely make sure that the other employees can get a 90-day trial. That's perfectly fine. So somebody's asked a really good question around the tax impact or the tax implications when it comes to paying for hurt and humiliation. Look, they say it's a tax-free amount. It's usually not captured by IRD or anything like that. It can be sent straight to the employee's bank account, or you can discuss a payment plan. I do believe to a certain extent there is certain amounts that may get recognized by IRD, but it usually, if you can show that it has been something that's been settled as part of an employment complaint and it's been initiated as part of a personal grievance, then that is fine, and it will be a tax-free amount there. So in terms of, so I can see here that there's a question around what the employer did in that Parker and Magnum Hire case to lead up to that massive payout. So the first one was a constructive dismissal. The second one was also that they had disadvantaged the employee and into two avenues. So basically what happened there was that the employee suffered great, they had depression, they had anxiety, and it was exacerbated by their working conditions. So the fact of how they were treated in the workplace, they felt quite heavily bullied, and usually that's what will attract that higher amount. Now, the salary cap, look, to be honest, we got a question here around the salary cap and whether that includes sexual harassment, personal grievances. It we don't know yet, if I can be completely honest. We have no idea yet, and it will solely depend on you know, on exactly what situation it is. If your question is relating to the bans, then keep in mind that with sexual harassment, it can be a different situation. What we've seen is that if people take it as a human rights issue, their compensation amounts are way higher compared to what we see at the Employment Relations Authority or at the employment courts. So if it's relating to that, then it is definitely much, much higher. But I say that, and then we've got these cases kind of going up and up and up. So when did the bans come into effect is what somebody asked. The bans came into effect last year in 2023, but what we generally like to do is wait to see if there's been a pattern for the bans. So we try not to, you know, kind of jump ahead and see, and officially because of Parker and Magnum Hire and other cases, about 15 to 20 decisions, I believe, we've seen a pattern. So we know now inflation has well and truly affected that area. And in terms of, let's see, sorry, I'm just sifting through. Sorry, I'm just going through. There's quite a few questions here. So somebody's asked in the employment agreement if you can refer to the current legislation in relation to a personal grievance clause. Sorry, I realize that my calendar notification may go off, so please, I am so sorry if that does happen. And it's just a bit of music. But somebody did ask if you can have, you know, just a brief kind of explanation or something in the employment agreement around the current legislative changes rather than spelling it out in a clause. There should be some detail around the time frame that they have. Doesn't need to be onerous. I remember when I updated our agreements here and our templates that go online, it was literally just a sentence that was put in there. I would highly recommend to have that in there because it is an essential term and it's required under the Employment Relations Act to have information around the pathway if they need to raise a personal grievance. So I know Sophia, who is our lovely events marketing manager here, I know she's going to start telling me that we need to wrap up soon. So I promise we will do one more question before I get told to wrap things up. And I will try to get through as many of these after the webinar, so just keep that in mind. What else? So in terms of somebody's asked about the time frame for hurt and humiliation and how far back you can go, look, it really depends on the circumstances. If we look at constructive dismissal, for example, then you may be, usually constructive dismissal comes up because the employee, you know, may have been given an ultimatum to either resign or to be terminated, or maybe they've been told, look, you need to leave the business, we don't want you anymore, and they've effectively resigned, or maybe they've been bullied so badly that it's led to their resignation. All of those things can be compounded over a set amount of time. It just depends on the situation. Usually the main thing that's being considered is whether that personal grievance is raised within that time frame. And we look, you know, for the way that the courts have done it is that they've looked at how long this has been going on, what the severity of the harm is, you know, how does this sit in with other cases, and you know, what evidence has been provided. So it can range. And somebody's asked around, sorry, Sophia, don't hate me. I'll do one more. Somebody's asked around the training wage and what defines a training wage. Usually it's an industry trade organization or somebody that you've partnered up with to bring on a particular employee. That may be an intern, or they may be doing some sort of placement and training. You know, usually we see this in the trade sector or maybe in hairdressing, for example. So all of those industries will generally have some sort of program, and that's when they would be part of that training wage. All right, perfect. So I think what I will do is I will wrap this up. I know we've got lots of questions still coming in, and I will definitely, like I said, be providing the slides, all of this information to you. We will be sending that out, as well as the recording for today as well. If you could bear through my voice and you wanted to listen to this again, then thank you so much. And thank you for not switching me off. Now, I just wanted to say thank you, everyone, for joining us today. I wanted to just leave my information here on the last slide, I post quite regularly. I am now officially a content creator, it seems, when it comes to employment law. I know, the world of content creation and influencers. So if you do, feel free to give me a follow. I put out information all the time about changes in employment law and insights into the industry that may not be as obvious when you're kind of navigating the day-to-day. So thank you so much, everyone. I hope you have a lovely, lovely day. And a survey will pop up automatically after we wrap this up. And we'd really appreciate if you took a minute to just participate in it. I just want to know if there's anything that we need to tweak or change, or that we can do better for next time, or maybe you really loved it. So, you know, no harm to my ego if you did like it and you did leave a good review. So thank you so much. Like I said, we'll be sending out additional resources, and just have a wonderful afternoon, everybody. Kia ora, and yeah, thank you so much. We'll catch you in the next one.